how to move, when to move, whose responsibility it is to help somebody move, all of those things. One of the key takeaways here that we just want you to stress with all of you is advocacy and sort of vehement argument on behalf of your clients can get you really far, in that there isn't going to be an exact right answer to a lot of these sorts of situations, and it is very much a negotiation. And so, just know that we obviously are here as a resource for you, and we will give you the legal support that we have to be able to make some of these arguments and to help your clients make some of these arguments. But just that this is still very much a developing area, and one that, in particular, as it relates to our clients who experience violence, that is still very gray. So, starting off with a little.
Hey, Amy.
Yeah, go ahead.
Sorry, I'm just going to jump in really quick because I forgot to hit record. Can you and Tracy just quickly reintroduce yourself and then just hop in? It was just the beginning part.
No problem. Tracy, you want to start it off again?
Sure. So again, everyone, my name is Tracy Thomas-Card. I'm the Advocate Support and Grant Manager here at Standpoint. I've been working in the movement since 2004, doing both direct service work with victim survivors and prevention education training. And then here at Standpoint, my role is to be one of the 3 full-time advocates staffing the action line Monday through Friday, providing support and triage to the victims, advocates, and attorneys, and other professionals who are accessing our phone line for assistance.
And my name is Amy Palmer Laricella. I am one of 5 Standpoint staff attorneys that are here to answer all of your questions and, to the extent necessary, offer referrals in a specific area of law. My expertise is in employment law, civil rights law, and doing survivor rights work for the past 10 years or so. And then more recently have developed an expertise in housing law, as so many of our clients require some support around this area as landlords and property managers and a variety of other folks in Minnesota, as well as just under the federal laws, do not understand what their obligations are. So here at Standpoint, we do a whole lot of counseling and information sharing around what should be happening. And then a lot of what our work today with all of you here is going to be is helping to arm you with information that then you all can use and you can help your clients use to better advocate for themselves as it relates to their housing rights. You want to review these fast again, Tracy?
Yeah, just a quick recap of our objectives. We will be reviewing the housing protections at both the state and federal level. We'll provide strategies for the clients that you're working with. And throughout this webinar, we'll go through a number of hypothetical situations based on calls that we've seen and advocates that we've spoken with related to housing issues that are coming up. And then we'll conclude with some resources.
And as you can see, we're super excited about it because we have an alligator jumping out of the water. I don't know. Okay, so jumping right in. Tracy, do you want to do this one?
Sure.
Oh, where'd you go?
So,
there you go.
Yep, I'm here. Sure. So for the state housing protections, we actually have a law in Minnesota. 504B is the statute, and actually we've had victims and advocates call us and just state the statute number. And so certain law enforcement agencies are giving out this statute number to victims and advocates that might be in contact with them. So if you get a call asking about 504B, what it is it's the state housing protection. And so it says any tenant in Minnesota who is a survivor of domestic abuse, stalking, or criminal sexual conduct and is not in subsidized housing may break their lease to get away for safety. And we'll talk about federal protections that are in place for folks with subsidized housing in just a second here.
All right. So according to what the law requires, there are a couple of steps that clients need to take in order to actually break their lease legally and walk away after experiencing domestic sexual violence or stalking. So the law allows for certain kind of documentation that he needs to be provided to the landlord or the property manager. It could be an order for protection. It could be a no contact order or a DANCO. Sometimes people respond with signed documents from a court official or signed documents from law enforcement. Most often, though, what we see are statements from a qualified third party like a healthcare professional, a sexual assault counselor, or a domestic abuse advocate. And what that really means is just, it oftentimes looks like just a letter. And the letter will state, I am an advocate at X agency. I am working with this client as they have experienced domestic violence, sexual violence, or stalking, and they need to break their lease. That's about it. It can be pretty minimal. This link down at the bottom is a link to a fact sheet that Law Help MN has prepared, and it actually has templates that can work and that agencies can take to prepare and fill out on behalf of each client. And one of the things that I think is important for all of us to know as we continue to serve our clients is the law doesn't require that we specify exactly what the person has experienced, right? And so oftentimes, in order to preserve as much confidentiality around this on behalf of our clients as possible, what we can do is we can actually list out, I am working with a client who has experienced, and then you can actually list all three: domestic, sexual violence, or stalking. And that is enough to put the landlord on notice that that the statute has been triggered and that the person can break their lease. So just sort of a little suggestion there for those of our clients that really don't want to share a whole lot of information about what they've experienced. That can be something that's helpful. And then additionally, clients themselves need to give written notice to the landlord. Again, this is going to all be in this fact sheet packet, and we've got another link at the end of the presentation too to help all of you. But really, all that written notice has to include is that the person is in fear of violence right now that they have experienced, that they need to end their lease, the date in which the person will move out, meaning, if we're right now, let's see, what is it? The 19th today of June. The lease term oftentimes ends every single month, right? At the end of the month. So we're looking at June 30th. So I could right now today put in a notice saying I'm ready to move June 30th, or I could put in a notice on June 29th and say I'm ready to move June 30th. You do not have to give appropriate notice that would be required under the lease or other kinds of areas of law. There is no specific time period in which a survivor needs to designate in order to move and give the landlord information on. The only thing is that they have to actually be able to move out by that date, right? And if there is going to be anything that is left behind in the apartment or the unit, designating to the landlord in writing, what to do with that what to do with that in materials and those properties, and then just including whatever documentation they want to actually include. So it might be that letter from the agency, or it might be the OFP. And also something to think about here, because a lot of clients recently of ours have been dinged for this. Clients are still responsible for the typical move out procedure. So it means, if you don't clean the apartment appropriately after you vacate, a landlord may still come back and say, well, we had to bring in cleaners because it was not in a clean condition, and so we're charging you for that. So one of the things that we've been suggesting now is that folks actually walk around the apartment once they've gotten all of their belongings out of it, and to take pictures, so that landlords cannot come back afterwards and say, oh, well, there was damage done and we needed to clean it up, or we needed to pay somebody to fix it. So some of those sorts of things can be really helpful and useful for clients. Anything else, Tracy, on this one that you want to point out?
No, I think that covers it.
All right, good deal. Additionally, what this law 504B allows for is, we like to flag these for folks just because oftentimes landlords do not recognize that this is a state law. Tenants do have the right to call the police, and not just the police. So we're not talking about just 911, but we're also talking about any kind of emergency personnel or emergency call. And so if a landlord is attempting to evict one of your clients for police calls or for emergency phone calls, that violates state law. Even if there's a city ordinance that maybe exists, oftentimes they're called nuisance ordinances or crime-free ordinances. That these are laws that initially cities started enacting in like the 90s as sort of a tough on crime, tough on drugs kind of approach. And oftentimes what we're seeing is that in these being played out, they're being used in a discriminatory manner against both the clients that we work with as well as communities of color oftentimes. And they're actually in violation of state law, which trumps these city ordinances. There have been some legal challenges to these. That in Minnesota in particular, I want to say it was Faribault, that had one that was challenged by the ACLU here in Minnesota and was ruled to be in violation of state law. And so they are starting to go away and pull back. But again, a lot of the time, unfortunately, people don't know that there's this protection. So if you have a client that is being threatened with eviction because of police calls, oftentimes, the neighbors might even be the ones calling, let them know that they cannot be evicted for this, and that they certainly, or you certainly, could call us to get connected with either legal aid or another agency that might be able to help them navigate that. On to our first hypothetical.
Sure. So in this hypothetical situation, Tara tried to break their lease due to sexual violence they were experiencing with their partner. Tara submitted a copy of their order for protection, gave written notice to their landlord on April 15th, and returned the keys and moved out on April 20th. Now Tara's landlord is saying that they have to pay for next month's rent. What should Tara do? And so for the hypotheticals, we definitely invite you to put your comments in the chat box, and Rachel will help by reading through the answers that we have. And then Amy and I have some suggestions as well. So we'll give you just a minute.
Do folks have any thoughts, Rachel, about what they might be able to do for Tara?
I'm not seeing anything. I think you have them flummoxed.
All right, so we're hoping that this can be somewhat interactive, folks, for those who are on the line. And again, it's fine if you don't have any thoughts on this one. We'll kind of kick it off and maybe start thinking and sharing some thoughts around what might be helpful in the situation. Trace, do you have any suggestions on how you might assist Tara with this situation?
Yeah, my first go-to with this is always to, as an advocate, I would get in touch with Tara's permission, get in touch with the landlord, and give them a copy of the statute that says that Tara is allowed to break her lease and cannot be charged for the next month's rent. So that would be my first step.
Yep. So oftentimes when we get this phone call, what I will run through with clients when they're calling is, okay, have you given appropriate written notice? What did that notice say? Check it against what the statute requires or against what the packet from Law Help MN dictates has to be in there. Did you specify the date? If there was property left behind, did you tell them what to do with it? Have you effectively returned the keys and cleaned the unit, and are you moved out? And so assuming that all of those things, the written notice and then the appropriate documentation occurs, Tara has done everything that she needs to under the law to be able to walk away. A copy of their order for protection is absolutely appropriate documentation according to the statute. And so ultimately, if the landlord is still saying that they need to pay next month's rent, even after you share that statute with them, it's not a comfortable feeling, but I guess trying to reassure your clients that if anything were to come from this, what would happen is the landlord would have to take them to court and say, you owe me rent, or you owe me, let's say they had a early termination lease clause and they're trying to get paid under that. And ultimately, so long as the client followed what's required by the statute, that lawsuit will not be successful, and it's on the landlord to do something about it. So as long as Tara has followed what's written in the law and has moved out, Tara will not be on the hook for any of that, other than just, unfortunately, still having to go to court to do it.
And I know, as Amy said, that can be really scary as an advocate or as a victim to be told that you might be taken to court. As an advocate, I always try and reassure the folks that I'm speaking with that this is not something that they have to do alone. They can certainly have an advocate accompany them should it come to that point. But the reality is we have not seen situations where it does come to that point. And generally what we're seeing is that once landlords are made aware of the statute, there tends to be far less pushback.
Yeah, and then usually, even if they still continue to push and say, oh, well, you still owe me for this, when told or started to be ignored by the person who's moved out, again, assuming that they complied with the law, eventually it typically just goes away. Again, not a super comfortable thing, but because it requires affirmative action on the landlord's part, and action that is unlikely to be successful under the law, oftentimes it fizzles out.
And I see we did have a participant post as well that they would provide the statute info to the landlord. Excellent thinking.
Perfect. All right. Now we're going to do, well, I guess maybe before we shift to some of our federal protections, I want to give folks an opportunity to ask any questions they have about what our state law allows for or protects.
And Tracy, we're also, can you make sure that your microphone is right in front of your mouth? You're a little bit harder to hear.
Yes, I will. Let me know if this is better.
That's good.
Much better, much better.
Are there any questions at all, Rachel, at this point?
There are no questions at this point.
All right, good deal. Well, then I think we're going to continue moving forward and talk a little bit about what the Violence Against Women Act says as it relates to our federally subsidized housing. So the area of law that we were just talking about is a state law created in Minnesota. It is a law that applies to private landlord-tenant relationships, meaning the tenant is paying directly out of their own pockets. The tenant does not receive any kind of federal assistance or federal subsidy to live where they're living, and it applies to those private landlords. Now what we're shifting to talk about is what sorts of federal law protections are out there for folks who are receiving assistance from the government to live in certain places. It could mean that they live in an actual subsidized, maybe a Section 8 building or something of that nature. It could mean that they receive a voucher where they can then apply a certain amount of funding or credit to a living situation. It can look a lot of different ways. There are lots of different kinds of subsidized housing. And without getting too much into the minutia, I just will say that depending on the kind of subsidized housing a client might live in, their rights to move or change their housing arrangement might vary. So we're going to cover the broad strokes of what these protections are and the ones that apply to all of the different kinds of housing options under VAWA. But just know that if there's a particular question or issue that you're having with a client that pertains to a specific kind of housing or voucher program or, any kind of subsidy, call us and Rachel or I can work through it and get some more specific information for you. So just as a recap, Violence Against Women Act has quite a few housing protections in it as it relates to domestic violence, sexual violence, and stalking victims. The sexual violence component is somewhat new, right? Recently, as of this past decade, was inserted, but the housing protections themselves have existed for over a decade. And so these are really strong and relied upon protections that actually go above and beyond what our state law allows as it relates to our private housing rights. And ultimately what I think sort of the main takeaway is that there are kind of two ways that these protections come up. Essentially, if you have a client that maybe doesn't yet live in subsidized housing but is applying to live in subsidized housing, what VAWA does is it prevents somebody from prohibiting them from accessing that housing based on the domestic violence or sexual assault that they've experienced. So what that might mean is the person may have an eviction action on their record, or a UD for folks who have been doing this work for a while. They used to be called unlawful detainers. If somebody has an eviction action against them that can be connected back to the domestic violence relationship that they were in, or an assault that they experienced that resulted in, let's say, damages to the unit or unpaid rent because they couldn't access the funding or the money, things like that. If ultimately the mark on their record is related to the violence, what VAWA does is it allows the client to apply to live in that subsidized housing and explain that the negative housing record that they have is actually due to the violence that they were experiencing, and that should be set aside and not considered when the person is applying to live in this subsidized housing. And then now this link down here that I've included too. So this is the separate link under Law Help MN. We already connected you to the private fact sheet, the private tenant fact sheet. This now lays out a little bit more information for folks to go to after this webinar for those who are in subsidized housing.
Okay, so clients who already live in subsidized housing have protections in place that prohibit them from the following factors: lease violations due to domestic or sexual violence, getting evicted or terminated due to domestic or sexual violence, or being billed for damage caused by the person who harmed them. This is for folks who are already in subsidized housing.
Yeah, and oftentimes the way that we see this come up is, somebody may be living in subsidized housing. Perhaps they're living with somebody who's harming them. That person may, again, be in the process of being violent. They may have damaged a lock on the building, or they might have punched a wall, and that wall then has to be replaced, right? Some of those sorts of things. Oftentimes what you'll see is property managers will say, well, this can't happen. This is a violation of our lease arrangement. You all have to go. And what then a client needs to do, and what oftentimes advocacy can help them with, is file a notice. There is a form that you can get to through that link that I just put there, that essentially puts the property manager on notice that the client is a victim of domestic violence, that says they have rights under VAWA, that they cannot be evicted based on that violence, and they also cannot be billed for the damage caused by that violence. So it would be on the property manager to replace that wall or to fix the lock, things like that. It also then, beyond that, adds in a couple of other protections that allows the client and the victim to, let's say they want to stay in their own unit, but they need the person who's harming them to be removed from the unit. So VAWA and providing that notice to the property manager gets that process started of actually pulling the abusive person out of the apartment or the unit that they're renting, and then it allows the victim and then their family to stay there and remain on the lease. Or in the context of many of our clients, they don't want that person to know where they live, so it allows them then to move to a different subsidized unit on account of their safety. One thing to note here, just because you have the right to move does not mean that you will actually, there would be a vacant unit. So one of the things that we always tell advocates here in this situation is, if you're working with a client who wants to, let's say they want to port their voucher because they have a Section 8 voucher, or they want to move from one subsidized housing unit to another, making sure that there is an available unit is really important before actually providing the notice that you're going to be leaving, because the last thing that we need is for folks to just be out couch hopping, in particular if they have family with them too, while they're waiting for another unit to open up, because unfortunately VAWA does not guarantee that they'll be able to find another unit that is vacant and that is available. So just things to think about. And then also just another caveat, depending on the kind of subsidized housing that they get, the process of actually finding another unit sometimes is on the client to do. Sometimes it's on the public housing authority to do. It widely varies. So yet another thing to kind of dig in with them on. If they have a public housing contact within the public housing authority, making sure that they're in communication with them. And so when they're providing that Violence Against Women Act notice to the property manager, also ensuring that they're communicating with the public housing authority about what they're experiencing too. Because ultimately, if, let's say, they have been in an abusive relationship and their rent had been calculated based on the income that the abusive partner was bringing in, but now they're fleeing from that abusive partner and they're no longer with them, they even have the right and the option of having their rent recalculated. And so oftentimes their income decreases because they're no longer with that person. And so that might even get them a better benefit. So there can be a lot of helpful things that come out of this notice process with both the property manager and with the public housing authority. So we've got another hypothetical, and we'll see if anybody has any thoughts on it.
All right, so Mai calls your crisis line. They live in public housing and one of the property management staff sexually assaulted them. They've reported the assault, but the property management company has not removed the staff member. Your client sees them every day and is feeling very traumatized and worried for their safety. They've been told there are no other housing units available at this point. What can you do?
We're going to give you a minute because this one is a little more detailed. We're throwing a lot of stuff in here at you all because, this is 201 and we know all of the things already. So we'll give you some time. Do we have any thoughts yet from our attendees?
I am not seeing anything yet.
Tracy, why don't you kick them off? What do you think you might start with here?
Sure. So in this situation, this is clearly a federal housing protection, right? So the client, in this case, definitely does have the right to either transition into a different housing unit or to stay in that housing unit, but to have the landlords and property management put protections in place so that they don't encounter the staff member anymore. I think the first thing that I would talk with Maya about in this case is to potentially file a protective order against the staff member, since they are continuing to see them every day and they're feeling very fearful. So that would be a first step that I would take. The second step that I would take, though, is to actually reach out to the housing unit and to advocate on Maya's behalf to see if there's a reason why they haven't yet removed this staff member. So that's where I would start. And then, Amy, I'll let you take it from there.
You bet. Yep, that's what I was going to say. Is there's still oftentimes, even though we're in the housing arena, there are a lot of different tools that are going to be available to advocacy and to clients. So I think the HRO is a great option. Oftentimes, too, I'll see if an HRO is obtained against somebody, like an employee of a company, and the company is then made aware of that, they will take action to separate that person to avoid, oftentimes it's because they don't want the police being called to their properties because of violations of these orders. So that can be a really effective, immediate first step for safety. I also want to, this is sort of something that's a little off topic, but I want to flag this since it's part of this hypothetical, is employers have obligations to ensure that their staff, especially their staff when working, are not harming other people and are not committing crimes against other people. They also, in this instance, property management company has an obligation to ensure that their tenants are safe. And so I think this is also one where calling me to have a consultation just about what options there might be for a civil suit against the property management company, or probing whether this has happened before or if it happens again, could be a really helpful thing. Just to have some of those conversations, because oftentimes if there's an attorney that gets involved and talks to the property management company about the liability that they have, they will take action to separate that staff member and potentially to even terminate that staff member. Now, on the housing side, I think that's absolutely right. Contacting the property management company and actually asking, where are the housing units that you manage, and are there any coming available in the next month or two, can be really effective. One of the advocates I work with, their client had been calling almost every day to ask about available units, and they were not responsive to that client. But the second that our advocate called and started saying, listen, you have obligations under the Violence Against Women Act to assist this person, they became very cooperative and were able to identify a new unit within a couple of weeks. So sometimes that on its own can be very effective. And then again, depending on the relationship with the public housing authority, notifying the public housing authority, and then depending on the kind of voucher that this person has, they actually may be able to locate another available unit. So it could be with a different property management company, but it still could be part of that same eligible pool of properties based on the kind of subsidy that the person is getting. So staying in contact there can be really helpful. And then just sort of a caveat is, moving within the same public housing authority region is one thing, and oftentimes there's not really a specific timeline for that has to be followed. There's something that's called porting, P-O-R-T, port, where you're actually moving outside of the housing authority geographic unit, and you're going to be working then with a different housing authority. Sometimes that is another option as well. So assuming you have a client that is willing to move out of, say, the school district that they've been going to or something of that nature, oftentimes that can be another effective way of finding available housing. Any other thoughts or questions that have come in discussing hypothetical 2?
I don't see that any questions have come in at this time.
Excellent. Moving right along then. Tracy, what are some ways that advocates can help?
Yeah, so Because we are seeing just such an increase in the amount of calls around housing issues, I wanted to talk just a little bit about the different strategies that I've used as an advocate and that I've also provided as options to the folks that are calling in on the action line. I put safety planning up there for a couple of reasons. First, we do have clients for whom they are being harmed, but for whatever reason, it is not a good time or choice for them to leave the housing situation that they're in. And so that's where safety planning really comes in handy. And I do have a really great resource that I'm going to share with you all today on that. I put the written statements to the landlord in here. This is something that Standpoint is happy to review statements that you might write on behalf of your clients or that your clients might want to submit. This is always something that you can call us and run by us. Say, hey, does this sound strong enough? Does it sound like it complies with the statutes? And we're happy to do that. I mentioned this previously, but having copies on hand of both the 504B statute and the VAWA housing laws to provide not only to your client, but also to the landlord or the property management can be really handy. Like Amy mentioned, you know, sometimes landlords just aren't aware of the laws that are in existence out there, and then providing them that documentation and paperwork saying, hey, this really is a law that exists can sometimes make a big difference. And then last but not least, you know, contacting landlords on behalf of your clients to do follow-up work. So oftentimes clients will reach out to us after they have maybe worked with an advocate initially, or maybe they haven't worked with an advocate initially, but they've submitted the proper documentation for the lease to be terminated. And then they're getting pushback from their landlord or their property management company and not knowing what to do. And this is where I really think that as advocates, you really have a positive role that you can play in the situation for your clients. As Amy mentioned, sometimes clients who've experienced that harm and trauma are just not in a place where they can fight or push back with landlords. They might not know that they can do that. And so as an advocate, that's where you can come in and say, you know what, I can call the landlord, I can come to these meetings to support you, and really just pushing back and advocating for your clients' situation can be really helpful. And then Amy, we can go to the next slide. So this is just a quick interlude slide. We've had a couple of situations come up. These laws are fantastic, but what do you do when your client is in a position where either they're choosing to stay in the situation or it's not a good decision for them to break their lease at the time? And so that's where I think, Amy, if you can flip to the next slide. Oops, we're doing a hypothetical instead of the slide I thought it was, but that's just okay. That's.
Do you want to try this one first?
This,
And then I'll
this is the slide I was thinking of. Thank you. And so that's where I think safety planning really comes in handy. So loveisrespect.org, and we have this linked at the end of the webinar for you, but they have an interactive safety planning guide that you can use with your clients. They have one for clients who are not in school or workplace situations. This is more of the generic safety plan that they have available, but you can go right online, or your client can go online if it's safe for them, and it asks them to consider various aspects of their lives where safety planning might come in handy, from things like your routes home, who has access to the keys of your house, to things like school or your job or technology and safety planning, emotional safety planning for children and partners. So a lot of times we're getting questions calling into the action line where folks need to leave a situation but may not be able to leave the housing that they're in because their kids are in a certain school district, right? So how can you make sure that your kids can go to school safely while still remaining in that housing unit? And so just really thinking through things like that with your clients when they're in a place where they feel like they can't leave the situation is an important part of advocacy in terms of housing situations. Okay, Amy, we can go back to that hypothetical. All
Sounds
right.
good.
So for this hypothetical, you are working with a client who's been in an ongoing domestic violence situation for several years now. Client has 2 small children, and although you've given the client the options to leave their subsidized housing unit and transition to another, more safe location, the client refuses. They say that they believe they can work it out with their partner, and because the partner doesn't ever harm the kids, that's not a concern. So thinking through what you might be able to do in this situation, it can often be really hard and frustrating as advocates to see a client that we've been working with continue to be harmed. But to know that it's definitely up to them. They have the agency and autonomy to decide whether or not to leave that situation. But how can we best support them? So we'll give it just a minute. Okay, Amy, you want to kick it off with what you might do in this situation?
Sure do. So, and at this point, we're talking about somebody who is living in a subsidized housing unit, right? So we're talking about federal law and federal protection. Um, the crux of this issue right here, though, is that this person is really, they're not wanting to move. And additionally, it also sounds to me like they're not looking to get a protection order or something that might limit their
Amy, could you
interaction.
move a little closer to your mic?
Oh, sure. Can you hear me now? Is this
Yes.
better?
Yep, that's
Okay.
better.
Okay. So
Could you start over though?
Yep, let me start that again. Yep, no problem. Sorry, all. So what we're looking at is a situation where, we have somebody who is receiving a federal subsidy. So we're talking about somebody who already likely is at a poverty level or somewhere around there. They do certainly have rights under VAWA, but it sounds like they are not at this moment looking to exercise those rights. And for a variety of very well-founded reasons, they're not in a position where they want to leave the person who's harming them. And so, not only are we not really looking at what sort of move or porting options do they have, but we're also probably not looking at a protection order in this situation because it sounds like they don't want to be separated or removed from their partner. And so just thinking through with them some safety planning options that could be something to rely on for if and when harm does start happening again. And I don't know if you have some thoughts, Tracy, as to what that might look like for this client.
Yeah, I mean, I think in this case, talking with your client, making sure that they have a plan in place should the violence start to escalate, should they decide that they're ready to leave. Are there transitional housing options or temporary housing options that you can talk with the client about, just in case they need to get away for a night or two to get away. I think too, although the client says that the children aren't being harmed, making sure that you're planning with your client, talking with the client about how to talk to their children if they should witness violence occurring in the household. What can they do to be safe? So this is one of those situations where it's hard as an advocate to watch the person that you're working with be harmed, but knowing that they have that agency and autonomy to decide to stay in the situation, really the only thing you can do is to continue to provide that ongoing support and those options for reporting or transitioning out of the housing at some point when they're ready.
Mm-hmm. Yep, exactly. I mean, it sounds like the advocate in this situation has done what they need to do in terms of letting the person know that they have options and they have avenues to safety should they need them again. And so ensuring that you're not shutting them down and continue to remain a resource for them is important. So moving right along,
Hey,
what are
Amy,
we doing? Oh, yeah.
can I ask a quick question? I'm wondering,
Sure.
when you're specifically talking about that last hypo and the fact that they're in these subsidized housings, is there any concerns that you've had from people who are afraid to leave a subsidized housing unit for fear of the fact that they would lose their eligibility for public housing?
Absolutely. I mean, under the Violence Against Women Act, there is an explicit protection that the violence that somebody has suffered, or perhaps the eligibility that the client had if it was tied to the person who's abusing them, that does not go away, right? So the VAWA protects that right to housing, even if the person who's harming is really the reason that that benefit was there in the first place. Now, again, I'm not going to get too far down this road, but there can be some caveats to that, in particular with undocumented folks. And Rachel, of course, Rachel is our immigration attorney for all of you who may not necessarily know that. And so Rachel certainly can do some counseling with the person if the person is undocumented and is concerned about losing the benefit there, around what that might look like, because I could envision a situation where somebody who's undocumented living with a partner who, the partner being perhaps a U.S. citizen and has access to this subsidized housing benefit, being concerned about losing that, because that, as far as I understand, Rachel, that can happen. Is that accurate?
Yeah, absolutely. I mean, my understanding is that, exactly as you said, if they want to separate and they've been maybe in this public housing together, that they would have to be independently eligible for the subsidized housing. So when you're working with people who aren't documented and aren't independently eligible for that housing, that there could be some concerns or issues with the fact that they may lose that benefit.
And just know that you can always call us and we will help triage this issue for you all and your clients to identify what benefits might be available, what is something that might be an option for the client if they are in that position.
Awesome. Thank you, Amy.
Mm-hmm. Any other questions before we jump into just a quick thing on Safe at Home?
Nope, no other questions.
All right, thank you. So we put Safe at Home in here just to talk briefly about another option that you have as advocates to provide your clients with. It's one that we would definitely urge you to talk pretty thoroughly with clients with as you're giving it as an option. But what Safe at Home is a program in Minnesota that allows victims of violence, not just victims of violence, certainly other folks can apply for the Safe at Home program as well. Advocates can apply for it. Law enforcement officers can apply for it. But typically in our situations, we see victims requesting it. And what it is it's the program that allows victims to keep their address confidential by having a Safe at Home provided P.O. box. Now, the reason I say that we need to talk really, really thoroughly with clients about what this means is that having a Safe at Home address is only as good as the folks who have that address can keep it confidential. So that means things like if you regularly get, I don't know, a subscription box delivered to your house, that would need to end, right? If you want to deliver pizza to your house, that would need to end. The more people that know your actual physical address, the less effective the Safe at Home program is. But we put this in here, one, because it's an option for victims of violence, but also because we are starting to see an increasing number of calls on questions where somebody's physical address, if they're enrolled in the Safe at Home program, has somehow been violated, has somehow been made public. And so we're starting to get a lot more calls on what do we do in those sorts of situations. So Standpoint recently had a meeting with the Safe at Home office. They actually have a lot of guidance in place already for these situations. And so their recommendation was that if you're getting these one-off questions about the Safe at Home program, definitely referring folks to that office directly, as they likely have experience and guidance that they can offer and can sometimes intervene on behalf of the participant in Safe at Home.
And so, Tracy, I think one of the things that you're referring to here is oftentimes we see courts not necessarily understanding why somebody who is a participant in the Safe at Home program is not disclosing their address to the court for things like service and stuff of that nature. And so they're Safe at Home is in a position to provide a lot of that information and resources and then technical assistance to the court and statutory guidance to the court on why this is the way that it is and the process that has to be maintained. Because there's a certain amount of information that can be shared with the court, but there is also like specific address information that cannot and should not be shared.
Thanks,
okay, so we're about to jump into a few hypotheticals here, everyone. So just gonna, we'll run through these with all of you, but I wanna make you aware that there also is gonna be sort of a frequently asked questions section at the end where some of the things that we're working through in these hypotheticals, we will then go back and summarize so that you have a lot of this in writing. And articulated as you continue to do your work in these resources. So hypothetical 4, we have Layla. Layla submitted a statement to their property manager company in order to break their lease after they were sexually assaulted. Now the company is claiming that because there are other tenants on the lease, that Layla is responsible for finding a subleasee. What can Layla do? Does anybody listening to the webinar here know what terminating Layla's lease means for the rest of the tenants on the lease? I'm guessing Tracy knows.
Yeah, I'm not seeing any comments, so I'll go ahead and jump in.
No worries.
So this is actually a situation that we get calls on pretty frequently. And the reality is when you are breaking your lease under, let's just say they're breaking it under 504B, it terminates the lease for all of the people on that lease. So if Layla has roommates that are living with them, it actually terminates the roommate's lease as well. So there is no responsibility on anyone's part to find a sublessee. Now that being said, sometimes roommates in question and landlords in question have struggle to understand what they should do in this case, right? So even though the lease is terminated for all the tenants on the lease, that doesn't mean that Layla's roommates can't renegotiate with the landlord to have a lease of their own that leaves Layla off of it. But it definitely does not mean that anybody there is responsible for finding a sublessee. And so that's, as an advocate, this is where you can be really helpful to your client by just explaining to the landlord that nope, it not only does it break Layla's lease, it actually terminates the lease of everybody involved, and you're welcome to renegotiate with those other folks.
And then one other piece of information that we oftentimes find can actually end up being a barrier for folks who are trying to terminate leases that have multiple tenants on them. When you terminate your lease under the statute, you can't be required to pay any of those penalties that early lease termination might bring up, but the landlord does have the option of keeping the security deposit. So by breaking your lease under the statute, it forfeits the security deposit, and the landlord can keep it. Now, that obviously can sometimes be kind of a financial impediment for folks, and so these are things to just talk with your clients about and ensure that their client is also communicating with their roommates that I need to do this. This is for my safety. This is for my security. Unfortunately, it may mean that the landlord retains the security deposit. Perhaps there could be some level of negotiation with the landlord to see if then that security deposit could be applied to the new lease negotiations, right? Landlords certainly have the option of being kind and decent humans when it comes to this stuff. It doesn't mean or guarantee that they're going to be, but it's just something to sort of flag for folks and make sure that they're aware of this situation.
All right, hypothetical 5. Charlie calls and tells you, the police told me I needed to get a protective order to keep my ex off my property. Do you know if I qualify? And if so, how do I get one? And Amy, I think in the interest of time, it might be best if we just kind of walk through these and then head to the FAQs at the end.
Mm-hmm. Yeah, this is another situation where, we're obviously, we have some housing options that are flagged in this kind of situation, but we also, as advocates and as attorneys advising survivors, want to talk to them about more than just the housing issues that they might come up with, right? So we do see this often where either police say you have to get a protective order, or perhaps a guardian ad litem says that you have to get a protective order because of a variety of the legal circumstances that the person is experiencing. And so ultimately what I do in these situations is I talk to the person about, okay, well, what is it that you yourself want, and what is it that you need? Is this something that you feel you want to keep yourself safe, or if there are other people involved, to keep them safe too? And then just thinking through, are we looking at possibly an order for protection, depending on the nature of the relationship? It sounds like they have been intimate partners. They might have even lived together. Perhaps the ex still lives at that address. An order of protection can certainly be one way of immediately getting that person removed and staying away from that piece of property. And then also talking with the individual, if that's the way that they want to go, about whether they want to break their lease, since obviously their ex knows where they live. If it's somebody where perhaps they actually didn't necessarily have that significant relationship and they never lived together, maybe there's a harassment restraining order option in there where at least you can have the no contact between the two parties. It's likely not going to necessarily protect an address, so still something to think about. But this person, Charlie, still is going to likely qualify to break their lease if what they experienced is something that we can articulate as domestic violence, sexual violence, or stalking. So just finding out some more information from this person as to what have they experienced, what went on that led the police to tell Charlie this, and then what ultimately does Charlie want. Moving forward, hypothetical 6. We've got Alex. Alex experiences a sexual assault in their apartment, and it's by their roommate's partner. They are all students at a local college. Alex has one overlapping class with the person who assaulted them. Alex wants to ensure the roommate's partner stays away from them and does not feel safe returning home. What do you tell them?
Yeah, so in this one, I think there are a lot of different things to pick apart. So let's start step by step. One, they were assaulted by their roommate's partner. So I think first and foremost, if they're comfortable having a conversation with their roommate to see if their roommate is either willing to ban said partner from the apartment. If roommate's not willing to do that, then it's talking with your client about options for filing protective orders in order to keep that person off of the apartment. I will say this depends. So if they are in student housing, for instance, there may be rules that they need to follow under the school's misconduct policy. So that's another option that you might want to look into for this situation. In terms of the overlapping class with the person who assaulted them, so that's where this turns into a Title IX issue, and Alex is afforded protections under Title IX as well, including that the school has an obligation to make sure that Alex feels safe in their learning environment. And so that could be making accommodations for Alex so that perhaps the person who assaulted them switches sections and attends the same class but in a different time or a different location than the one that Alex is attending. It could also mean that the school does an investigation as to whether or not student violated a misconduct policy. So there's a lot to pick apart here. I think, too, the fact that Alex is not currently feeling safe to return home, depending on the type of housing that they're in, contacting a landlord on behalf of Alex with Alex's permission to see if there are other housing options available for the meantime might be something to work on. You could also do some safety planning with them. But first and foremost, the first step I would take is having that conversation with the roommate to ensure that Alex can feel safe in their home. And then, Amy, do you have other things to add to this? There's a lot to pull apart here in this one.
Absolutely. Yeah. I mean, it's just ultimately it's going to come down to what Alex wants, and how, if Alex wants to continue to stay in that class, helping them, assisting them to do so where they don't have to see the person who's assaulted them, or getting an HRO against that person to prevent them from being there, or breaking their lease under the private state law that breaks the lease for everybody and then allows perhaps Alex's roommate to find and arrange for a new roommate situation and continue on and start a new lease with that person, and then allowing Alex to leave. It can go any number of different ways, and it ultimately just depends on what Alex is looking for.
All right, hypothetical 7. So Sam 911 on the roommate after a situation occurred between the roommate and partner. Now the landlord's threatening to evict Sam because of all the police activity. Sam's worried about finding a place if they're evicted because this was actually one of the only apartment buildings in their county that accepted pets. They have 2 dogs together. What can be done in this situation?
Yeah, so, this unfortunately still does happen a lot where landlords, because they don't want to get on the radar of the city with a number of phone calls to the police, say, you need to stop doing this or I'm going to evict you. I guess ensuring that Sam understands that that cannot happen, and if the landlord were to institute eviction proceedings against them, there actually are quite a few attorneys that can handle those sorts of cases. Legal aid does a lot of eviction work, and especially when you're looking at a situation where there's limited housing available, um, that is something that is going to take high priority. So working with them to perhaps connect them with an attorney to prevent that from happening if it does, and ensuring that they understand that they have state law protection against that. And then also just again, talking through with them what their options are to ensure that they and their roommate are, that Sam and Sam's roommate can either continue to coexist if that's what they want to do, and how do they do that safely, or if they want to, figure out a way for the roommate and the partner to move out. We oftentimes get this call from folks who say, I have allowed a friend to stay with me. They are becoming, one of them is becoming violent against the other one. I don't want them to be here anymore. What do I do? It's kind of a variation here on hypothetical 7, but a little more context. So in those sorts of situations, you can't just, you can certainly ask the roommate to leave, or the person who's staying there to leave if they aren't actually on the lease. Now, if the roommate's on the lease, then, we're talking about a different situation. But if it's just somebody who's been staying there as a guest, you can't automatically trespass them, but you can go through a process of providing them notice that if they continue to stay for after a reasonable period of time, that you are looking and considering them to be trespassing and attempting to go that route. If they've lived there for an extended period of time, Sam also might be in a position to evict that person. Or if Sam has a lease, Sam's landlord might be in the position to evict that person, right? There are a lot of different variations here that do come into play. I do not expect all of you to be able to understand all the nuances and have that in the front of your brain all the time. And so that is totally okay. And calling us in this kind of situation to think through what sorts of options might there be available to Sam to ensure that if Sam wants to stay, Sam can, and how do we continue to work with the landlord to ensure that that can happen in a safe way. Do you have other thoughts on that, Tracy?
Yeah, I think just to add on to that, I think in this scenario, it's pretty obvious that Sam is a secondary victim in this case. And so talking with Sam about how to potentially support their roommate and whatever choices their roommate makes in the situation is going to be critical. It can be very hard to see a friend go through a violent situation, particularly if you're in a cohabitation together. So working with Sam, not only to do safety planning for Sam, but also for their roommate as well.
Excellent. Rachel, have there been any comments or anything before we do our last hypothetical here?
Nope, no comments.
Great. Moving right along. Tracy, you want to do this
Yeah.
last one?
Yep. So the last hypothetical we have, Jaden is a client that you've been working with. You've helped them break their lease and they moved out of their apartment last month. This month, they're receiving a letter from their landlord threatening them with collection action if they didn't pay charges for cleaning bills, carpet replacement, and utilities for before and after they left premises. Jaden tells you that they paid the utilities before they left, but obviously they didn't pay any after they left the premises. What can you do in this case? There's a lot going on here, a lot that the landlord is threatening them with.
Yeah, so it sounds like, assuming that Jaden broke their lease and moved out of the apartment in a way that comports with the law, obviously Jaden does not necessarily owe any additional future rent money or future utilities under that lease because the lease has terminated legally. Now, that doesn't mean, though, that there might be other things that Jaden would be on the hook for. And so this is where some negotiation and I think communication with the landlord can be helpful. So Jaden potentially forfeited the security deposit. Not every landlord knows that they can keep it, right? So sometimes that goes, sometimes that doesn't. If the security deposit is being returned to Jaden, perhaps Jaden suggests that some of the cleaning bills actually be paid with that security deposit. There can be something like that that occurs. Or if the carpet was old, or excuse me, was soiled and needed to be cleaned or replaced, suggesting that that occur. But again, it's going to depend on the condition that the unit was left in when Jaden moved out. If Jaden was in a position where they weren't able to get photos and aren't able to prove the condition of what the apartment was in, oftentimes the landlord is given a little bit of leeway in saying, well, the carpet was pretty damaged. It was really new. It's only been in there for 2 years, let's say. So Jaden, we expect that you would be able to pay a reasonable replacement fee for that sort of thing. This can go a variety of different ways, and there actually isn't a ton of very clear law on what to do with charges and what to do with the return of the security deposit that is forfeited oftentimes when breaking their lease. And so what we at Standpoint here can do is sort of help strategize with advocates and their clients about how to maybe go about finding some common ground to allow everybody to walk away and feel like they have gotten at least some reasonable accommodation from it. But just knowing that, ultimately it is still on the tenant to, at least under the state law, if you're breaking your lease, to clean the apartment, to ensure that it is in good condition, and then also to be aware that any damage beyond just normal wear and tear, and there's sort of an understanding that like carpet lasts 7 years or paint should be redone every 3 to 5 years, right? So assuming that that's not what's going on, normal wear and tear, but if it's more of like damages, clients still can often be charged for that if what we're dealing with is just a private landlord-tenant relationship. This is not subsidized housing, so they don't have protections from some of those damages the way that federal law allows. But then the utilities, of course, you don't have to pay future utilities. Once you've broken your lease, the utilities and the responsibility to pay them are done as well, assuming that Jaden canceled those utilities, the ones that Jaden was responsible for. Other thoughts on that one, Tracy?
No, I think you covered it. That's a big one there.
Yeah. Okay, so we're going to do just sort of a little recap, kind of making sure that we get all of the highlights for all of you. First, Tracy, do you want to go through some of these housing resources?
Yeah, so a lot of these we've referenced throughout this webinar. So just the first one is the what we call the Breaking Your Lease packet. It's got the private protections available as well as the federal, the VAWA protections available. It really documents things very nicely, exactly step-by-step process that your client would need to go through in order to terminate a lease early due to experiencing domestic or sexual violence. And that can be found at Law Help MN. Love is Respect is the website that I referenced earlier that has both the interactive safety planning guide as well as printed guides. Some people like printed copies better. The interactive safety planning guide I highly recommend. It's accessible in multiple languages and really walks through step by step the various areas that you might want to think about safety planning when you're working with clients. Then we have Homeline. Homeline is a resource that you can access to ask, potentially to ask legal questions about housing and also to get resources for housing for clients. And then searching for public and private housing, we've included the link for Housing Link.
Okay, so diving into just sort of our recap, frequently asked questions that we get. I think we'll kind of just go through these rapid fire and
yeah, I think so.
See how it goes. So, Tracy, do I get to keep a security deposit if I break my lease under the private state law 504B?
No, unfortunately, you do not get to keep that, Amy.
Will I have to pay for damages on my apartment when I move out under private state law?
Yeah, so potentially you do have to pay for damages. It's really going to be dependent on the landlord and the property management company as to whether they'll charge and what they'll charge for.
And then also just sort of as something to note here, some landlords will be willing to use the security deposit that is forfeited to cover some of those damages. Others will not, and there is not clear law on this right now. So just to flag for folks that, being able to negotiate is certainly a good thing because the law doesn't actually say either way if that forfeited security deposit should go towards any damages or cleaning fees or, things of that nature. So something to keep in mind there.
And again, this is if your client is able to, this is where documenting and taking pictures before they leave the premises could be really helpful.
Absolutely.
Amy, will I have to pay rent for beyond the month that I move out?
Assuming that you've broken your lease under the state law and what is required for appropriate notice and documentation, you do not, Tracy.
Great. And what if there's other tenants on the lease?
I think everyone knows this by now after our hypos. They also have their lease terminated and have the option of renegotiating their lease with the landlord.
Yeah. Can the landlord force me to give the name of the person who hurt me?
Ooh, yeah, we haven't talked about confidentiality yet, which obviously, we over here at Standpoint get super excited about. No, the answer is no. The landlord cannot force you to give the name of the person who's harmed you. We see this come up a lot where landlords are worried oftentimes about the rest of the folks in their buildings. And they even, they're well-intentioned sometimes where they're just trying to get more information about what has occurred so that they can protect others from experiencing that same thing. But ultimately, our state law as well as our federal law ensure that confidentiality for victims is still paramount. And so, no, the landlord might ask, they might come back and say, hey, can you tell me the person who's harmed you? Or, obviously, if you're providing the order for protection, you're going to be giving it to them. But if you're going the route of the domestic violence advocate letter, likely that information is not going to be included. And so just know that that's why oftentimes we see folks prefer that route, because the least information provided is best for some of our clients, and they do not they cannot be forced to give over that info.
And the last question on here is, can the landlord share the reason I'm leaving with others?
Again, fun with confidentiality. No, they cannot. They very well may need to alert a couple of people within their property management organization to what is happening and to terminate the lease, but they cannot tell even the other tenants about it if the person who's breaking the lease has chosen not to. And so just noting and helping the landlord understand that they have confidentiality obligations here can be really powerful as an advocate, to say, all you can do is tell folks that the lease is being broken, and if they would like to sign on for a new lease, they have the option of doing so, and you'd be willing to negotiate. Because the protection for victim survivors in this situation, the confidentiality protections are really strong. Oh, the other caveat to this is, if the information is being given to the court for purposes of collecting like unpaid rent or back rent or things like that, then in that case, of course, things can be shared. But, save for just those limited exceptions of due to court proceedings and things of that nature, the landlord should not be sharing that. All right, so now we're going into a little bit more of like what happens when we're talking about somebody who lives in federally subsidized housing.
All right, so do VAWA protections cover private housing as well?
The answer is no. VAWA protections only cover those that are in federally subsidized housing. But again, there could be state laws and other protections that apply. Something that we're not going to get into in this webinar, but just know that there is something called the Fair Housing Act, and that is a federal law that applies to virtually all housing everywhere. So there are still going to be some protections that prohibit discrimination for a variety of things that may come into play, but just understand that the Violence Against Women Act housing protections only apply to federal housing. Okay, Tracy, what if I need to get the abuser out of the home?
Yeah, so the housing authority might evict the abuser alone and let you and your family stay. So this is what's known as lease bifurcation. If the housing, though, was based on the income or eligibility of the person who was doing the harming, then you and the family, or your client and their family, can prove eligibility for housing protection on your own to be able to find new housing. So the answer essentially is if the person who is causing the harm needs to get out of the house, there is ways to do that to allow the family to still remain.
Yep, and those protections will apply not only to the person being harmed, but then also to the folks that are their family members that are living there too. I mean, the reality of this is, unless you're looking at a situation where, like we talked about a little bit earlier with Rachel, where you have an undocumented person who's the one being harmed, in most instances, if the family unit qualified for subsidized housing, when you remove the abuser and the potential income or lack thereof from the equation, oftentimes that family still will qualify for that subsidy, even potentially more of a subsidy in that case. So just something to kind of think about as you're advising people. What if I need to move to escape the abuse, Tracy?
Yeah, so if you do have a Section 8 voucher, clients can choose to do what's called porting a voucher, which essentially just means moving to another unit with that voucher. So other federal programs must have emergency transfer programs, and so you just really need to ask the landlord or the housing authority to provide the plan if you don't know what one your client falls under. And that will give you the information that you need to know whether or not you can move to escape.
And yeah, so what we have been finding as we advise folks that are receiving a variety of different federal benefits is it widely varies depending on the benefit that you have. So you have to dig in a little bit with your clients to identify what is the benefit, and then either going back to the public housing authority and say, okay, so as a Section 8 voucher member, what is it that is available to this client that will allow them to live safely? They're supposed to have plans and explicit policy around this, but what I can tell you is from doing this work now and advising folks around the state, public housing authorities widely vary in how developed their process and their protocol is. And so oftentimes the folks that advocates have been communicating with really don't know or have never experienced or had to do any work under VAWA before for a variety of reasons. So just, ensuring that you have as much information as you can going into it to be able to advocate on behalf of your clients, connecting with us to help to better understand at least what the law and the regulations require based on that specific benefit. And then additionally, when we're talking about somebody who qualifies for subsidized housing, they likely qualify for legal aid too. So keeping that in mind, most legal aids do lots of housing representation that affect or interact with public housing authorities, and they likely have lots of relationships to use and to work with in order to help somebody move to escape the abuse. So if you have a client who's lagging and they've put their notice in and nothing's happened yet, get in contact with us to help understand the timeline that's supposed to be followed and see if there are resources out there for representation.
And I think just another thing to quickly add to that, Amy, as an advocate, something that you can proactively do in your agency is to reach out to the Public Housing Authority office, get to know the staff members there so that if you do have a client who falls under the public housing situations, you already have a contact there that you can establish a relationship with to work with them on that. That might go a long ways versus waiting until you have a situation and then you meet your public housing authority staff for the first time and they have no clue what VAWA is. So really just being proactive as an agency would be a helpful strategy to take on. Amy, how do I prove that I can use VAWA protections?
Yeah, so it's a very similar process under federal subsidized housing. And again, you have that packet that's available to you that we included the link to. So again, you're going to fill out sort of a self-certification form. That's the HUD form. You'll include a letter from a victim service provider, like a domestic violence or a sexual violence advocacy organization. And then there might be a police report or court record or administrative record that you would end up including as evidence of the abuse. And there can be some back and forth with the public housing authority or with the property manager where they ask for more information. And depending on what that information is, sometimes you might be obligated to provide it and sometimes not. So if you're finding that there is some concern about how much evidence of abuse are we providing and what's the time period in which to provide it, give us a call and we can talk through that a little bit more in depth with you all. But just know that that packet online is going to be really helpful for you in that situation. Okay, so really quickly, we've got, can the housing provider share information I provide about the abuse? Is it any different, Tracy, for federal housing under VAWA versus the state law?
It is not. They cannot share that information unless you agree to its release in writing or if it's required to be released by law.
And then does this mean survivors of violence can't be evicted from public housing?
Yeah, so this is a question that we get pretty frequently. This does not exempt survivors of violence, unfortunately, from being evicted from public housing. But what it says is that survivors need to be held to the same standards as any other tenants. So they can't be evicted simply because they're a survivor.
Right. But so, if the survivor themselves are actively participating in violation of the lease in drug usage or are allowing certain kinds of criminal activity on the premises, those are some common ones that we see in federal housing that you cannot do. Unless that can be linked very clearly to the violence that the person is experiencing, there's no additional protection beyond just you can't be evicted because you are a survivor.
And last question, how do these protections change if I move out of Minnesota?
And the answer is they don't. The Violence Against Women Act is a federal law, so it's going to apply in any state in the union. Obviously, different states have their own private protections, like our state law that allows a private landlord-tenant relationship break of lease situation. That may be different in other states, but the Violence Against Women protections for federal housing still apply. Rachel, do we have questions or anything from folks that are tuning in?
I think no specific questions, but I also wanted to make clear that when you're talking about moving out of Minnesota, how does that work with the Safe at Home program?
Ooh, good question. Tracy, you want to take it or you want me to?
Oh, I'm sorry, Rachel, can you repeat the question real quick?
Yeah, I was just talking about the Safe at Home program. So what if I'm enrolled in the Safe at Home program, but then I move to Wisconsin? What happens?
So it's actually a kind of a nuanced question. It's a great question though, and something that we have clients do fairly frequently. So different states have different programs, but not all states have programs like Safe at Home. So my understanding, and Amy, feel free to weigh in on this, but my understanding is that, in fact, I recently worked with somebody who had moved out of state, was in Safe at Home here, and the protections still applied out of state. That being said, whether or not the state that this person now lived in can enforce them, that's a whole different situation. So I would recommend if you're working with a client who is in Safe at Home and is going to look to move out of state, call the Safe at Home office, see if they have an equivalent program in that person's state. I think it will be a much smoother transition process if they're able to enroll in a program in the state that they're about to become a resident of.
Awesome. Thank you, Tracy.
Yeah, you're welcome.
Any other questions or comments? Or Rachel, anything else that you'd like to add? Y'all, Rachel is the other housing attorney, so I know she's moderating and facilitating this webinar, but she herself could have given it too. So I just also want to give you the opportunity if you had anything else that you want to flag for folks.
No, I think you guys did a really good job, and obviously as
Thank you.
Well, as both one of the attorneys who handles housing issues and one of the attorneys who works with immigration issues, just to know that those two things, when they combine, can get quite complicated, and we are here. We are here for you. So everything today, we're here to support people as they move forward, dealing with some of these issues.
Absolutely. We've included our individual contact information on this slide. Do feel free to reach out to any of us. You certainly can obviously call our action line, and whoever answers will be able to connect you or the client you're working with to any of us that do this work. But just know that we're constantly developing resources around this because it is quickly becoming, I think, the largest area where even we need to do additional building, both within our own staff as well as how we're informing the rest of the advocacy community in Minnesota. So if there are things that any of you either didn't see covered on today's webinar that you have questions about, or you would like to see another webinar that does a deeper dive on, we are always open to that. And really just trying to find the best way that we can to support the really great work that advocacy does in Minnesota, because there are not enough attorneys to do the housing work that is out there that needs to be done on behalf of our clients, and advocates do it most of the time do it better than the attorneys that I've seen anyway. So, Tracy, any other thoughts from you?
No, I was just going to put out there that if you're working for an agency and maybe not all of the staff in the agency was able to see the webinar today, feel free to have your staff, new and experienced staff, check out not only the this webinar, but the recording from the Housing 101 webinar. I think it answers quite frankly, answers a lot of the questions that we get coming into the action line and will help prepare you as advocates that much more to effectively serve the clients that you're working with. And again, just to reiterate, if you are looking for advanced training or additional training on this topic or any others, please feel free to reach out to us anytime.
All right, I think that is probably it from us. Just know that we appreciate all of you advocates doing this great work, and to just let us know how else we can help you. Anything else you need to say, Rachel? I don't know what the script says.
Nope. I think we're good to go. So thanks, everyone. Just look for our next webinar. It should be coming up in about a month. But I'm going to stop the recording and end the meeting. So thanks, Amy and Tracy.
Thanks, everyone.